Well, good morning, everybody. My name is Sasha White QC, and I'm a member of Landmark Chambers, and welcome to our second part of our webinar on a comprehensive guide to the latest planning law, practice and policy. And I hope everyone's comfortable and enjoying the surreal experience of hearing us through your computers or iPads or phones or wherever you are today across the UK. I just wanted to say a lot of you will have already been on our webinar last week. I just wanted to give a few introductory points. The webinar will last an hour and a half. It's going to this morning comprise 3 presentations, and then we'll have a question and answer session at the end. My name, as I've said, is Sasha White, and I will chair the session today. I'm joined by my 2 excellent colleagues, Zack Simons and Matt Fraser. Zack is an incredibly highly rated planning specialist and was identified in Planning Magazine as one of the 2 leading planning juniors in the 2020 survey. He regularly appears in planning inquiries in the High Court, and frankly, it has a really bright future ahead of him. The same is true of Matt Fraser, who is also going to speak today. He's very highly rated, and I commend him to you. He's also been a junior to me on many occasions with huge aplomb and competence. As most of you know, and I won't bore you by repeating, I'm obviously a planning QC who specialises in public inquiry and High Court work. Now, this morning we're going to cover 3 topics. I'm going to finish off my presentation on planning appeals from the past 12 months. Matt will look at the 10 seminal Secretary of State decisions of the past year, and then Zack will cover how COVID-19 is affecting decision-making for LPAs currently, which is of course highly topical and relevant for all of us during the lockdown. Can I just say, on a personal note, I want to thank everyone for joining us. I know lots of you are getting bombarded with all sorts of presentations, webinars, etc., etc. And I think it's extremely kind of you to join us, and we're very, very happy to have your company for the next hour and a half. Can I also just give a few housekeeping points? Your microphones are automatically muted, so no need to adjust your local sessions. We welcome use of the question and answer function at the bottom. We will endeavour to answer the most topical questions at the end. We will also answer in written form the questions that we received last week and this week, and you should receive that. We will also send automatically the slides this afternoon, so all of you will receive them. And also, if any of you have problems, which is, well, we did last week, if anyone loses the connection, do just press the original invite and that will rejoin you. Can I make 2 final points before we start? If you have found the webinar benefit, as I said last week, we're trying to obviously do this to inform everyone, but we'd also love a donation to the NHS on the Just Giving website, the COVID-19 NHS page, and it would be appreciated hugely by us and others if that was done. Secondly, can I say, I think in order to keep things interesting at the end, I'm going to read out the best lockdown story, and I'm going to start, if those of you who want to contribute do. My best lockdown story so far is the surreal nature of putting on a suit, which you'll see in all its glory at the end when we do the question and answers, knowing you're walking down the stairs to your study, you'll do the webinar and then take the suit off at the end of the webinar. So do provide your best lockdown stories, and we'll provide a prize at the end to the most amusing lockdown story that a contributor makes. Now, I also wanted to say, enjoy the webinar. Do give us suggestions at the end. I know it's interesting that the planning inspector are considering 4-6 hour Zoom sessions potentially for appeals, but I know an hour and a half is certainly a long time to keep your attention. So please enjoy it, and we'll try and make it as interesting and as informative as possible. So I will then start with my presentation, and I'll leave the 3 beautiful faces facing you right now. And presentation. which is, as I said, the first thing I want to deal with is effectively the key theme 12, which is how an inspector's considering neighbourhood plans. And of course, that's highly topical. And the first case I wanted to discuss was the approach in Mid Suffolk. This was a very recent appeal decision in Eye. And this is interesting because it's a proposal for 126 dwellings on a greenfield site. And the neighbourhood plan, the emerging neighbourhood plan, had looked at the allocations in great detail, not chosen the appeal site. The proposal was not allocated, and the inspector found very seminal part of the decision was a conflict with the emerging neighbourhood plan, and it being undermined was decisive in refusing the scheme. So that's quite illuminating in relation to where the weight given to even an emerging neighbourhood plan prior to referendum. The second is a classic case for 46 unit sheltered housing in Arundel, and it was acknowledged in that case that the HLS shortfall existed, but a policy in a neighbourhood plan that had been recently approved in a referendum sought a range of housing accommodation, and the proposal did not consider all the development options as enshrined in the neighbourhood plan policy, and therefore the proposal should be dismissed. So we then move thirdly to a case last autumn from South Oxfordshire. This involves a site that was effectively allocated in the neighbourhood plan for the development of 45 homes, but the proposal before the inspector was for a care home scheme for 78 dwellings. And the inspector took the view that the proposal should be refused as it exceeded the number of dwellings permitted to a significantly material extent, and the benefits would not outweigh the harm to neighbourhood plan policy conflict. And the last one is Aylesbury Vale, which was a decision from Long Crendon of last September, where full weight were given to neighbourhood plan policies in refusing a proposal for 65 dwellings. So you don't need to be a rocket scientist to clearly see that one simply cannot underestimate how important and determinative neighbourhood plan policies are currently being received and decided by inspectors. So next issue I wanted to talk about, and I know this is extremely topical for those that are landscape architects, is what approach is being taken to landscape and visual impact and valued landscapes. And I've got three decisions here. The first is in central Bedfordshire. This was a decision of 16th of the 3rd, 2020. One of the interesting things, I'm sure it's interesting that the site in central Bedfordshire has somewhere called Sunderland Road. Someone must have got lost somewhere. But this was a major mixed-use scheme of 228 homes on an edge of settlement site. The inspector took the view, quite strong words, that the appellant's landscape consultant had underestimated the visual effects of the proposal, and also the mitigation effects of the proposal had been overstated. The existing settlement boundary avoided urbanisation should be retained. The next in relation to a case in Hinckley and Bosworth is, however, an allowed consent of December 2019 where 80 units, the development there, the subjective judgment was reached that the development would not intrude into the wider area, and although the site was valued by local residents, it was not part of a valued landscape, and only very limited weight should be given to an emerging local plan and an emerging neighbourhood plan. Contrast that decision in terms of weight to the neighbourhood plan to the Eye decision we just looked at. And lastly, a proposal at Westleys in Charminster, a site for 120 dwellings, which was identified, excuse the spelling, but in Thomas Hardy setting, harm to the wider visual landscape and visual harm, and the harms to both heritage and landscape as such, the proposal would not accord with the development plan. Now, I think there's general consensus, which I certainly endorse, that landscape and visual impact has unquestionably grown in importance with the inspectorate over the recent past, and it is clearly justifying refusal, whether even on the tilted and of course on the flat balance. Now, one thing I've been asked about, and I think it's very topical, is the valued landscape position, because what you have, of course, I think it's just worth probably one of the most thorny subjects that we all have to address is whether a site falls within a valued landscape. Now, one needs to look at the chronology. Of course, March 2012 came up with this much vaunted phrase, and in the NPPF of March 2012, it was said that planning systems should contribute to and enhance the natural and local environment by protecting and enhancing valued landscapes. And all of us have been involved in various projects where some have chosen it isn't a valued landscape and others have said not. This obviously led to 3 significant High Court cases: Stroud, Forest of Dean and CEG land promotions. And the general gist of the courts is that to be valued landscape, there must be demonstrable physical attributes for the site. And of course, that didn't, in a sense, help on a day-to-day basis, because those that were seeking to identify it as valued landscape would say, of course, it's blindingly obvious there are demonstrable physical attributes. And those that said it wasn't valued landscape took the opposite view. Then we had, in July 2018, in the refinement to the NPPF, we had planning policies and decisions should contribute to and enhance the natural and local environment by protecting and enhancing valued landscapes. And it was said in a manner commensurate with their statutory status or identified quality in the development plan, which was not changed in the February 2019 edition. So I think what that means is there are essentially 3 active interpretations to what is now NPPF 170A, and that is what I've termed the subjective interpretation, when the judgment of the LPA is that it is a valued landscape, i.e. it is an open list based on the Clivia Box 5.1 assessment criteria, showing what constitutes demonstrable physical attributes. The second interpretation is an objective interpretation, which would be that we can only be a valued landscape where either has statutory status, remember the words commensurate with their statutory status, or quality identified in the development plan, i.e. it is a closed list, irrespective of the physical attributes. And then I've termed the cumulative interpretation, which seems to be gaining traction with the inspectorate for the 2 appeals I come on to in a sec, which it needs both to fall within the closed list. In essence, it needs to have statutory status or be identified in the development plan, and it also needs actual physical attributes. And the reason I come up with a cumulative interpretation, because you have the appeal decision of February in Mid Suffolk, again in I, where that was dismissed. And then one of the things the inspector said is the site fell within a special landscape area, so it clearly was identified quality in the development plan, but the inspector considered the site did not, notwithstanding that designation, did not exhibit any particular unique qualities or rarity, and therefore was not valued landscape. Then in the case of West Dorset, again the Thomas Hardy case, the site was identified as land of local landscape importance, and additionally the inspector considered the site was a valued landscape. So frankly, everybody, of course, wants complete clarity and certainty from me, but I tell you that valued landscape, the amendments that were sought to end the eternal debate about whether a site was a valued landscape, I think the debate is trundling on, and it will need some form of additional High Court interpretation or intervention in the light of the phrase used now in the February 2019 NPPF. So then let's deal with key theme 14, which is about the approach given to heritage harm. And I think unquestionably in the life of the NPPF, additional weight has been given to heritage. We see that in a very recent decision of the 23rd of March in Coopersale, where a proposed dwelling was proposed within the walled garden of a listed house, a new dwelling. Harm to the heritage assets were not outweighed by the benefits contended, which was a costly restoration of the walled garden and the repair of the curtilage wall and the reinstatement of what lay within the walled garden. That was not deemed to justify in the 196 balancing exercise the harm to the heritage asset. However, in Swale, we note a large appeal for 700 dwellings. Although a grade 2 farmhouse abutted the site, an extensive area would be retained, protecting the setting of the listed building, and therefore the impact was acceptable. In relation to a large town development in London at Tower Hamlets, proposal for 189 flats and commercial floor space. Harm to conservation area and listed buildings meant that NPPF 196 was not passed and the proposal was dismissed. Very similar approach in Crookham of the February on Valentine's Day this year. Proposal for 62-bed care home and residential apartments. Harm to conservation area listed buildings and the strong public benefits again were deemed not strong enough to outweigh the harm. And that's an example of where the tilted balance was disengaged due to harm. Then about highways, and of course, another area where we all debate is what does the NPPF mean in paragraph 109, talking about severe impact on highways. In East Herts, a decision relating to 29 houses, the allegation was that there would be harm, such that it amounted to severe impact, and the inspector found that the slight increase in queuing, any residual impact, cumulative impact would be small and well below the NPPF threshold, and therefore the proposal was allowed. And that's probably an absolute case study in how the government expected severe to be implemented. Next, in Mansfield, dismissed, and in that case, the inspector was not satisfied there would not be an unacceptable effect on highway safety or a severe cumulative impact on highway safety. It's quite interesting, that decision, because effectively the inspector said, in essence, the burden was on the appellants to satisfy them, the decision maker, that 109 was satisfied. The tilted balance did apply in that case because the policies were considered out of date, but even that, the inspector put substantial weight should be given to potentially adverse impact on highway safety, and the appeal was dismissed. Then, dealing with a decision from October last year in Cheshire West and Chester, would the proposal have a residual cumulative impact to justify refusal under 109? And the inspector concluded that there would be peak hour spreading, but considered there would not be significant harmful impact per NPPF 109. And then conversely, in Canterbury, last September, there an inspector did consider severe impact. Now, my overall summary would be that that severe impact and the 109 test does provide a reasonably high threshold in order to justify a refusal. Then let's deal with issues of accessibility. And of course, this is again largely dealt with in the NPPF. When is a proposal not considered accessible by inspectors? And a good example is in this case of November last year in Wokingham, down to the rear of Johnson's Drive, which was dismissed. And the inspector found that where you had walking distances to facilities, 1.2 to 1.4 kilometres, they would be generally considered too great. And also, the bus service that would be proposed was not within the development plan, in this case the core strategy of 2010, to be good. In Hertfordshire, we have a case again in Ledbury, which was dismissed, and there we have an outline application for up to 420 houses. Key services and facilities lay in excess of 1.5 kilometres. And again, the inspector concluded those were in addition to the IHT guidelines, and the proposal would be dependent on the use of cars. Appeal dismissed. The last one is the very recent decision in Wokingham, which came out last week. Some of you will have seen it. And this was a proposal for up to 118 houses. First of all, the appellant sought to compare the site to other places where the local authority granted consent. The inspector said didn't find that exercise particularly helpful because the most important point is whether alternative choices are available, and it's also incredibly difficult, frankly, to make a really valid comparison. Opportunities for the modal choice in that case remained limited, and it was likely that most journeys would be undertaken by the car, and therefore these matters are of very substantial weight and importance in the planning balance. And just to summarise this, I would unquestionably say that the question of accessibility is going up in importance with inspectors, and much more scrutiny has been given to this issue than historically. Next issue, I want to deal with climate change. And I think this is a question that is again rising in importance, but it appears remarkably undeterminative in the approach to residential planning consents. I'll welcome anybody who's got an appeal decision which they think climate change was determinative in the outcome. I didn't find in my research cases where climate change was considered determinative or fundamental. but I'm happy to be proven wrong, and I'll update the slides for future. But it is clearly generally what happens. It's considered under accessibility and sustainability. And I do note that many LPAs, such as Windsor, Maidenhead and Wokingham, have declared their own climate change emergencies, but it's probably not till the next draft of development plans likely to have policies with more teeth than currently utilised to deal with this issue. Then can I deal with next issue's costs? And I think I wanted, some of you will know of these decisions. First of all, I wanted to deal with Waverley, where a council contended at the commencement of the inquiry that they had a 5-year HLS. There was then a round table on the first day. It didn't go particularly well for the LPA. I know this because I was present in this decision for the appellants. It didn't go particularly well. The inspector asked the local authority overnight to consider their position. They did, and decided they would no longer contend they did have a 5-year land supply. The inspector clearly endorsed that view. There was an agreement between the LPA and the appellants, and the inspector endorsed that by finding that the appellants' costs should be paid. In Sevenoaks, this is quite an important procedural point about notification, because in that case, the LPA sent out a letter of notification. Again, I was involved in this, but they said to those members of the public that they needed to effectively register with the LPA prior to the start of the inquiry. The inspector was very nervous about this because the LPA had not responded to certain requests, and members of the public might have been discouraged from attending the inquiry. So we adjourned for 3 months to allow fresh notification without the requirement for the members of the public to notify the LPA. Then Tandridge. This was a case where the LPA members objected to a scheme on highway impact, but withdrew the objection the week before. And the inspector quite firmly took the view that this is an example of a development that should clearly have been allowed, and the LPA had misapplied policy and failed to keep its case under review. This is a case which emphasises that all those involved in the appeal process, particularly LPAs, must keep the process under review. And then lastly, Wiltshire. I just wanted to deal with a case of, this was Purton Road, Swindon, where the LPA had not been clear enough in their evidence about concerns of a wildlife impact in the reasons of refusal, and the appellant could not reasonably establish what was needed to overcome the concern. So the point I'd make in summary is that it's really important to seek to comply with the rules, procedure rules, particularly post-Rosewell. Then what approach is being taken to emerging policy in Harrogate? This was a recent decision in February of this year, 210 houses, tilted balance in play. But what the interesting, the inspector took the view, although the development plan was out of date, the emerging local plan was at an advanced stage with adoption imminent, and the housing land supply was healthy, and therefore the loss of the site unjustified. So quite a lot of emphasis placed on the emerging policy there. In Bedford, a proposal was dismissed, where effectively, although the LPA was again had a shortfall, the position would be changed by the adoption of an emerging local plan found sound by inspectors. So it was post the inspector's report, and the inspector gave significant weight to new policies. And the last case I wanted to bring your attention to was in St Albans, where a site was allocated an emerging neighbourhood plan, and along with its removal from the green belt, but the neighbourhood plan had not yet allocated the site, and the inspector queried whether a greenbelt designation could be altered by an emerging neighbourhood plan, and therefore predominance was given to the adopted development plan in that case. So I'm afraid, in summary, there's not a consistent line to the weight that's been given to emerging policy. Then in relation to greenbelts, I'll take this reasonably quickly because generally, I mean, the two upper cases, quite clearly what was the classic example was inspectors concluding that very special circumstances did not exist for standard housing sites in the Greenbelt, however strong the housing need was. In York, however, a different decision was taken, but this is slightly different because it was a former sports ground and the emerging policy sought to exclude the site from the Greenbelt. So in that case, there were obviously very special circumstances that did justify the grant of consent. But I would say in summary, housing need gets very little traction in the very special circumstances balancing exercise unless something else beyond housing need constitutes the very special circumstances. Now dealing to the AONB, and this is in Cheltenham. There was a case very recently of the 23rd of March where the permission was granted into a site that lay adjacent. However, in Bolney, that site was largely in the AONB, and the inspector clearly concluded that there were not exceptional circumstances. And again, the same approach in Herefordshire, not within, but within setting of AONB, and the harms significantly demonstrably outweighed the benefits. In summary, I would say proposals certainly within AONB and the major development test is extremely difficult to get through that. So nearly at the end of my presentation, what approach is being taken to design? I would say, of course, with the government's publication in September of the design guide, more emphasis on design. In Hillingdon, there was a large proposal for 81 flats dismissed very recently on the 26th of March, design unacceptable because of lack of any entrances and no active frontage. We used to joke about whether you needed an active frontage, but actually it has been given some importance. Again, a contrary approach, however, was in an appeal in the London Legacy Development Corporation, which I proposed for the appellant. In that case, the design quality of the scheme was a factor in favour of granting consent and clearly was heavily influential on the inspector's decision because of her conclusion that it was a high quality design. That was Jennifer Weiss, obviously a very experienced inspector. And then again, the same case in relation to Mansfield, where design was proposed that would include pedestrian accessibility for a tunnel to get to the site, and improvement to connectivity was a factor in favour of granting consent. Now, let me then leave the various appeal decisions and just deal with the latest position. We know that we have got a position where effectively appeals were suspended. PINs are looking into ways to decide what to do, and the same is true for local plan examinations. So no actual decision has yet been taken about the way forward and when appeals will recommence in whatever form. And obviously PINs is in lockdown. For those of you who have appeals in the system, the range of different views is quite remarkable, but we wait with interest when there's a formal decision by PINs of how to restart the appeals process. What is likely to happen in the future? If I could very quickly say, I think the system might well change materially with the lockdown, and we're all getting much more use, me included, to virtual technology. Rosewell unquestionably has changed the planning appeal system materially. Far more roundtables and less cross-examination. The example I gave earlier of the AONB appeal in Bolney, which I did in November of last year, 4 of the 6 topics were done by roundtable. Indeed, we did on one day, we did 3 roundtables in one day. Clearly, it's quicker and more inquisitorial with the inspector leading the charge. And we also say, in terms of other things to take a note of, there's likely to be changes to the assessment of need and use of the standard methodology. And my judgment is, as a result of the past 2 months, the government will revise the MPPF again in the autumn to provide an even greater presumption. Let me stress, that's my judgment. It's not based on any information to boost the economy materially in the light of COVID-19. So let me then thank you very much for listening, and I hope that was informative. Let me then please hand over to Matthew Fraser, who's going to tell you about the top 10 Secretary of State planning decisions over the past year.
Thanks very much, Sasha. Good morning, everyone. So Sasha's taken you through some of the inspector's decisions. I'm going to try and shift focus now to look at some of the decisions that have been taken at the Secretary of State level. Because I'm sad enough to have done so, I've read all of them over the last 12 months. Just trying to get my screen right. So over the last 12 months, there have been 17 decisions on recovered appeals and called-in applications between 15th of April 2019 and 15th of April 2020 that have involved some form of housing development as part of the scheme. Interestingly, 10 out of the 17 have granted planning permissions, so that's 59%. And of those that have been granted planning permission, all of the cases that have happened since the general election in December 2019 have resulted in a grant of planning permission. So 8 out of the 17 that have happened since the general election have been determined in favour of the appellant, which I think interestingly shows a confidence in the current government since they obtained that significant majority, and they're clearly exhibiting that by granting permission for developments that are being determined by the Secretary of State at his level. In 11 out of the 17 cases, the Secretary of State agreed with his inspector, so approximately 2/3 of the time. Just zooming in a bit more and looking at some of the trends within those decisions. Of the 11 cases where there was overall conflict with the development plan identified by the Secretary of State, only 4 were allowed. So it's quite a significant indicator of where you're going to end up if you're conflicting overall with the development plan. So only 1/3 of cases resulted in a grant in that situation. And then of the 6 cases where the proposal accorded with the development plan, unsurprisingly, all 6 were allowed. 5-year housing land supply, of the 11 cases where there was a 5-year housing land supply, 6 were allowed, so approximately half. So it shows that it's not necessarily disastrous. If there is a 5-year housing supply, there are still cases that are being allowed. And of the 6 cases that don't have a 5-year housing land supply, a higher number are getting permitted, again, unsurprisingly. Finally, what kind of effect is the tilted balance having? The tilted balance, for those of you who don't know, is where the proposal should be granted planning permission unless the harms significantly and demonstrably outweigh the benefits. That's NPPF 11D2. Of the 4 cases where the tilted balance was applied by the Secretary of State, 3 were allowed, 3/4 of the cases. And the one where it wasn't allowed is going to be one of the ones that we look at to understand why. And of the 13 cases where the tilted balance did not apply, 7 were allowed. So again, approximately half. So if you don't have the tilted balance, it doesn't necessarily mean you're not going to get planning permission. Starting with the first of the 10 decisions that I'm going to consider today, this is a case in Braintree. By the way, I'm going to be going through them in chronological order. So this was back in mid-June 2019, case in Braintree. And this case involved 1,600 homes and related development. It did not accord with the development plan, so the question was whether other material considerations would justify a departure. There was no 5-year housing land supply, and the Secretary of State gave significant weight to this contribution, and it therefore triggered 11D of the NPPF. So in that situation, planning permission should be granted unless the application of policies in the framework that protect areas or assets of particular importance provides a clear reason for refusing the development proposed, or any adverse impacts of doing so significantly and demonstrably outweigh the benefits when assessed against policies in the framework taken as a whole. And in this case, the Secretary of State agreed with his inspector that the proposal would cause less than substantial harm to a nearby listed building. So that threw the case into the balance required by paragraph 196 of the NPPF. And the Secretary of State found that the public benefits of the scheme, namely housing provision, various economic benefits, sustainable travel measures, surplus school places, open space provision, local centre employment land, etc., all of that was sufficient to outweigh the heritage harm that was caused. And as a result, the Secretary of State found that paragraph 196 of the NPPF did not provide a clear reason under NPPF 11D for refusing the development. So this means that the balance then shifts into the tilted balance, and it's a balance which is already loaded with a number of very significant benefits, as the Secretary of State identified. Whilst one might have expected in this case that would be enough to enable the proposal to be granted permission, planning permission was in fact refused. The Secretary of State found that the harms would significantly and demonstrably outweigh the benefits. The heritage harm was, of course, plugged back into the equation at this stage, but it was also taken together with other harms. The identified harm to the character and appearance of the area, a substantial adverse effect, according to the Secretary of State, from the loss of the appeal site, the loss of views and open outlook. And these impacts were afforded significant weight by the Secretary of State. And in addition, the Secretary of State found an appreciable diminution in the sense of separation between settlements. So this case is an indication that even if you do get the advantage of the tilted balance, it's not necessarily the case that you're going to get a grant of planning permission. The second case I want to look at is the case concerning the Chiswick Curve. This was a large residential tower block, part 32, part 25 stories in Chiswick. The site fell within the Great West Corridor and already benefited, the site itself already benefited from planning permission granted back in 2002 for a pretty ugly 13-story office building, which remains implementable even if it hasn't been completed for various viability reasons. So the effect of this was that the principle of a tall building was established on the site, and the inspector was waxy lyrical about the design of the Chiswick Curve proposal. He described it as a quite brilliant response to the difficult problems presented by the immediate context of the site. And it's rare to see such praise heaped upon a design proposal by an inspector. It's worth having a Google and looking at what the scheme looked like if anyone doesn't know. But the major issue in this case was the heritage impact, principally to the setting of Kew Gardens nearby, a World Heritage Site. There were multiple viewpoints within the gardens themselves which would be affected by the tower. The inspector found that the harm was at the less than substantial end of the scale, and that the public benefits, the impressive design, the provision of housing, etc., would, in his view, outweigh the harm under the MPPF, under MPPF paragraph 196. So the planning inspector recommended approval, and indeed when the matter came before the Secretary of State, the ministerial submission that was drafted by the Planning Casework Unit also recommended approval. However, the Minister for Housing and the Secretary of State disagreed with the recommendation. They struck the balance under NPPF 196 quite differently, and they saw that the design merit was outweighed by the heritage harm, which was the subject of I think the design, it's fair to say the design merit of the scheme was the subject of more limited praise by the Secretary of State. The decision by the Secretary of State to refuse planning permission was then challenged in the High Court, principally on the basis that the heritage balance should have been conducted by comparing the appeal scheme against the relative impact of implementing the existing consent or developing in accordance with emerging policy for the area. So that was the basis for the challenge. And what was found by the judge, it was Mrs. Justice Lang. She dismissed the claim last month on the 10th of March 2020 and found that the Secretary of State had fully taken into account the inspector's views on the consented scheme or some other similar development. So that was the end of that challenge. Turning now to the third case I want to have a look at. This is the case of Pale Lane Farm. 700 dwellings, site. This is a site for, and in addition to that, a site for a primary school and local centre. And this is one of those cases where, and I'm sure many of the people listening will have come across examples like this, where the policy context changes dramatically from the date of the application, in this case back in November 2016, and the eventual date of the appeal decision in November 2019. 3-year difference, a lot can happen in planning policy in that time frame. You stick your application in and the development plan consists of a bunch of old policies saved from some old plan. There's no emerging plan, there's no neighbourhood plan, things are looking good. 3 years later, by the time the appeal decision is made, planning permission's refused. By the time the decision is taken, the examination of the emerging local plan, which didn't even exist at the time of the application, has concluded, as has the consultation on the main modifications, and the council agrees with the examining inspector's recommendations that to adopt a plan which can deliver the required housing without the appeal site. The emerging plan is therefore at an advanced stage, and to make matters worse for the developer, it's common ground by the time of the inquiry that the council can demonstrate 9.2 years of housing land supply. Not only is there no need for the development, the Secretary of State upholds the prematurity objection that was advanced by the council. The council said that granting planning permission for this scheme would predetermine the location of a significant urban extension that the plan making process had decided is inappropriate. And I think in some ways this even goes beyond the question of prematurity. Not only was the decision, not only was this predetermining a decision that had not been made, the decision had in effect been made. It was just a question of adopting the plan without the site involved. So to add to the appellant's woes, it was also determined that the effect of the scheme on the landscape character of the site would be significant and adverse, as would the visual effects. And another change since the application date, the neighbourhood plan, which didn't exist, had been previously examined and made. And unsurprisingly, the neighbourhood plan does not allocate the site for development, and this carries significant weight against the proposal. So to the developer's advantage, it was clear from the vintage of the local plan, which had not yet been replaced by the adopted plan, that the settlement boundaries and the countryside protection policies, these being the most important policies for determining the application, were out of date. But this didn't mean that the scheme benefited from the tilted balance. And that's because there was a harm to the setting of a listed farmhouse. And this meant that the NPPF 196 balancing exercise was required. And the public benefits were identified by the Secretary of State as being tempered by the fact that you had a healthy housing land supply, and the provision of an additional 700 homes was not needed, and therefore it wasn't enough to outweigh the heritage harm in that case. And that meant that there was a clear reason for refusal which deprived the appellant of the tilted balance. So the fourth case then is the issue of is the case of Burley and Wharfdale, Sun Lane. This was 500 new homes as an extension to the built-up area of Burley and Wharfdale. This is one of those cases where there are a huge number of issues falling in favour of the appellant. We're talking about housing land supply that was abysmal, less than 2 years. Paragraph 11D of the NPPF was therefore engaged. Although the site is 230 metres from an AONB, there was no resultant harm to the AONB, nor would it dominate views when seen in the context of the existing built-up area. Things got even better for the developer. There was no adverse impact on matters of ecological or nature conservation, despite the proximity of 4 different European protected sites. The biodiversity net gain was given great weight. Even more, although there was less than substantial harm to a conservation area and a scheduled monument, there are also significant heritage benefits. So in the balance, the public benefits were held to have outweighed the heritage harm. One of these benefits, one of the various benefits that's not yet been mentioned, was that the scheme would also be providing a new school, significant weight given to this, no material effect on the provision of medical services due to identified spare capacity, no flood risk, no severe traffic impact. So it's all looking fantastic for this development, except for one critical problem. It was in the green belt. The site was in the green belt, and it was found that the scheme conflicted with 3 of the 5 purposes of the green belt and constituted inappropriate development. And as we know, inappropriate development in the green belt will only be permitted in very special circumstances. So despite the glittering array of benefits in this scheme and other circumstances, they were not enough to outweigh the green belt harm, and very special circumstances did not exist. And this constituted a clear reason for refusing the scheme under NPPF 11D1. So the proposal never got to take advantage of the tilted balance, permission refused. Going to turn now to look at the case of West Ferry. This was a comprehensive mixed-use development in Tower Hamlets, including, among various other things, 1,524 homes. The site benefited from an existing planning permission for 722 homes and a school. There was an issue of adverse impact on the character and appearance of the area due to the scale, the height and the massing of the tower. However, only moderate weight was given to this due to an emerging policy indicating that the site would be within a tall building zone once that policy was adopted. So the Secretary of State decided that one could expect significant changes in building height in the near future. And in addition, the harm is mitigated by the design of the buildings. This was a case where 21% of the housing would be affordable, and the Secretary of State found that the scheme on the available evidence could provide more than the 21%, and therefore there was a policy conflict with the London plan. What happened? Permission was granted, and despite the fact that there was a policy conflict in terms of affordable housing, the Secretary of State quite interestingly said there's no evidence of any other scheme coming forward on this site. And there's also a late stage review that's been plugged into the Section 106. And therefore he still gave significant weight to the increase in affordable homes as against the fallback position despite the policy conflict, which I think is an interesting point to have made by the Secretary of State. In addition, he gave significant weight to the benefit in the provision of market housing, notwithstanding the existence of a 5-year housing land supply. Again, that's interesting and encouraging for housing developers. The combination of affordable and market housing was given substantial weight, according to the Secretary of State. Moderate weight was also given to social and economic benefits of additional employment over and above the consented scheme. So one has a conflict with the development plan overall, although less a substantial harm to the significance of heritage assets, including in this case, Tower Bridge and the Maritime Greenwich World Heritage Site. The public benefits were found to outweigh this, and therefore material considerations justified a departure from the plan. Sixth, I'm going to go through these a little bit more speedily now because I'm running out of time. The sixth case is in relation to the North London Business Park in London. More recently, this is a case of earlier this year. This is a hybrid scheme. And the key area of dispute was the impact of the elements of the scheme that were over 7 stories high on the character and appearance of the area. And the Secretary of State granted planning permission. They found that the scheme was acceptable, both in terms of scale and massing and design. They said that, as is typical of London, even in the suburbs, the tall buildings would blend in with the background cityscape. And the Secretary of State also gave significant weight to conflict with the local plan, as it is not a site allocated for tall buildings. This was a case where the housing land supply situation was pretty borderline, and actually the 1,350 market and affordable homes were a necessary ingredient in achieving a 5-year housing land supply. So the scheme itself was a requirement of demonstrating that sufficient provision. And on balance, material considerations relating to the scheme's benefits were sufficient to displace the outcome dictated by the plan. And interestingly, the Secretary of State also awarded the appellant its full costs of the appeal, and the appeal is also notable for the time it took for the Secretary of State to determine the application, the inquiry having closed back in November 2018, so a delay of over a year. 7, this is an appeal against, this is a Fiddington, Ashchurch near Tewkesbury, an appeal against a non-determination, 850 dwellings in the local centre. The site had very relatively, well, I think the site had recently been rejected for an allocation in the 2017 core strategy. And this is usually pretty disastrous for any scheme. If there's been a very recent plan making process and that site hasn't been allocated for development, that's usually a very bad sign. However, not in this case. Permission was granted, and what was found was that the reason for the non-allocation of the site in the local plan was down to a highways issue, which had subsequently been resolved by the time the appeal was determined. And this meant that the Secretary of State was pretty unimpressed by complaints made by the council that the scheme would undermine the plan-led system, especially where there was also agreed to be a serious and substantial shortfall in housing land supply. In addition to this, an acknowledged need for a review of the plan had made little progress. On top of this, the scheme itself had no problem complying with landscape policies. There was no highway impact. And in relation to affordable housing, the policy was providing sufficient affordable housing. So despite the allocation issue, the Secretary of State found that the proposal accorded with the development plan. In terms of material considerations, in addition to that, there was no policy of providing a clear reason for refusal. The harms did not significantly and demonstrably outweigh the benefits, and this resulted in planning permission being granted. I'm not going to dwell on number 8 for too long, simply to identify that for any cases that are involving affordable housing and the details relating to the amount of provision of affordable housing, this is an essential read, because that really was the single main issue in the case to do with affordable housing. It was a question of whether the affordable housing provision of over 20% was policy compliant, and it was determined that in this case it would be compliant, and that public benefits outweighed the less substantial harm. And interestingly, because it was a single phase development, the Secretary of State said there was no pressing case for a late stage review to be put into the Section 106. Now, 9 out of 10 were nearly there. 150 homes with public open space in open countryside outside the village settlement boundary of Long Melford. And this is one of those cases, again, where at the time of the inquiry, it was agreed that the council could not demonstrate a 5-year housing land supply, and therefore the inspector wrote their report recommending approval, applying the tilted balance. However, before the Secretary of State could make their decision, the position changed and the supply increased to 5.67 years. What did this mean for the appellant? Did this spell disaster for them? One of the key points of contention in the case related to a policy which required proposals to identify a local housing need and exceptional circumstances for development in the countryside outside settlement boundaries. And case law has established that local housing need in this context, when you're interpreting a policy, means housing need of the village itself, and perhaps also areas immediately adjoining the village. What did the Secretary of State decide? They granted planning permission. They were satisfied that local housing need could be demonstrated in the light of the evidence that was submitted. They were also satisfied that the settlement boundary in the policy was out of date due to it being old and not formally saved in the core strategy. And the requirement for exceptional circumstances in the policy, i.e. exceptional circumstances to build outside of settlement boundaries, was found to be inconsistent with the NPPF, where there is no suggestion that one needs to demonstrate exceptional circumstances simply to be able to build outside of a settlement boundary. And this therefore reduced the weight to be given to the conflict with those policies. There was only limited landscape harm, so moderate weight to that, moderate weight given to economic benefits, since they do not extend beyond the construction and future occupation of the scheme. So overall conflict with the development plan, but despite that conflict, material considerations prevailed. Even though there was a newly established 5-year housing land supply, the settlement boundary was out of date, the visual harm was confined to the site, the proposal would secure much needed housing. And again, an interesting observation, the Secretary of State expressly reminds all readers that the 5-year housing land supply requirement is a baseline, not a ceiling. And in light of the government's objectives and the identified local need, as well as the economic and other benefits, it was justified to depart from development plan in this case. Finally, 97 Barbrook Lane. Again, I can take this pretty quickly. Up to 200 homes and safeguarded land for school expansion on undeveloped land beyond a settlement boundary. There was a prematurity objection made because of an emerging joint local plan with other authorities. Despite this, permission was granted. The prematurity objection was rejected by the Secretary of State. They said that basically the plan wasn't sufficiently advanced to justify prematurity objection being made. The housing land supply was down at 4.7 years. There were no wider landscape impacts, no highway issues, no ecological issues. And so therefore, although it was contrary to the development plan, the housing land supply shortage activated the tilted balance, and the Secretary of State concluded that the harms did not significantly and demonstrably outweigh the benefits. So that's a quick canter through the top 10 most recent Secretary of State's decisions. over the past year. And I'll now hand over to Zack Simons, who's going to take you through the impact of the COVID lockdown on decision-making by LPAs.
Well, good morning. There were over 430,000 planning applications in 2019, which resulted in, among many other things, of permission for over 370,000 homes. This talk is a short canter through the steps that central and local government are taking at incredible speed to mitigate the damage to the planning system that the COVID lockdown has caused, is causing now, and could cause in the future. I will introduce you to the new regulations on local planning authority meetings and take us through pre-app into an application. We'll try and get a positive decision. Then I'll touch on appeals, as Sasha did briefly, and consider what comes next. And by the end of it, I hope you will be as heartened as I've been by the amazing work going on at almost every level to keep the system moving. Although we will discuss a couple of areas where more steps are needed and needed quick. So if you're sitting comfortably, only 2.5 weeks ago, the government brought into force these horrendously named regulations. They apply to council meetings until May 2021. The relevant bits cover only England, not Wales, not Northern Ireland. And again, bravo to the ministry, because the legal power to produce these regs in the Virus Act 2020 only came into effect a half before the regs on the 25th of March. This lawmaking in the fast lane. What changes do the regulations make? Well, it's about allowing councils to make planning decisions in a way that is consistent with the requirements of lockdown and social distancing. So how do these regs do it? First, members and the public to attend meetings remotely, and I will come back in later slides to a little bit more detail on how that works. Second, they allow meetings to be open to the public virtually, again, to be discussed. They allow documents to be open to inspection just by being posted online. As I say, I'll return to the detail of these ideas in a few minutes. Two important points to note at the outset. First, the regulations on virtual meetings override the council standing orders or rules. So an otherwise willing council is saved the bother of amending standing orders to make virtual meetings happen, which I think is a really sensible and efficient measure. And the second point, these regulations are not compulsory. They don't require anyone to do anything. And as we'll see in a few minutes, different councils are responding to them in very different ways. What don't the regulations cover? They don't cover how you apply, how applications are publicised, how decisions are appealed, and of course, nothing yet on difficult issues like SIL or expiring consents. And with that in mind, let's start at the very beginning with pre-app. The first and most obvious difference in this brave new world is that you won't be sitting across the table from your planning officer, but the vast majority of councils have not shut up shop. Pre-app meetings are still happening over Zoom, over Microsoft Teams and all the rest of it. But what about site visits? Well, the first question is whether or not they are legal during lockdown. And I think that's a question with a straightforward answer, because one of the exceptions to the general requirement to stay at home is traveling to work where you can't reasonably do that work at home. And I can't think of a job which fits more clearly into that description than a site visit, where staying at home would literally defeat the purpose of the exercise. But so much for the law. What's actually happening? Well, that depends on where you are. Some councils are content for site visits to go ahead. Many are not, and have imposed either total bans on officer site visits or a limit on doing them only in exceptional or unusually pressing circumstances. But all is not lost. Progress is still being made through greater reliance on digital tools like mapping services, and more important than ever, images in the pre-application materials. So here's the first big rule of making pre-app submissions, or indeed applications during lockdown. Do not skimp on the quality or quantity of your images. Lots of high quality pictures, please, because with the risks of moving forward without a site visit, application images have already taken on more significance than ever. So we've done our pre-app for Zoom and we are ready to submit. Most of the procedures on submitting and validating applications can still and are still going ahead perfectly happily under lockdown, i.e. submitting, storing documents, notifying neighbours over email or post, consulting the relevant bodies, receiving question responses over the internet as normal, writing up the officer's report. All of that can be done remotely. But what about venturing outside to post site notices? 3 quick points on those, and there is a question that's been asked already about them, which I'll take when it comes to questions at the end. But the 3 points on my slide: first point, you don't always need them. See the development management procedure order for further detail on all of that. One of the cases site notices are required is for EIA applications, and there's a further fly in the ointment there, because EIA regulations require copies of environmental statements to be served on the local planning authority and sometimes the Secretary of State, something that's not likely to be physically possible at the moment. So we can see the need for further amendments here ASAP to enable EIA cases to keep moving through the system. Second point on notices, and as for site visits, is that I think it would be lawful for local planning authority officers to leave home in order to post them under the exemptions in the Act. But third point, many are not. And again, this isn't the end of the world, because many councils are, I think, very sensibly sending notices to applicants and then requiring evidence that the applicants have posted the notices in the relevant spots themselves. However, don't forget about statements of community involvement. These set legally enforceable, legitimate expectations on the procedures that councils will adopt when publicising applications. So unless and until we get any new regulations to override them, the requirements of individual statements of community involvement still need to be followed, and followed carefully. What about deciding our application? Different approaches are possible. The first approach was adopted by some local planning authorities well before lockdown, and that is a general delegation under emergency powers to someone like the chief executive of the council to take all or most planning decisions for the time being. That will normally require triggering some kind of emergency provisions in the local planning authority's constitution, an urgent solution for an urgent time. On the one hand, it's a way of ensuring that the wheels of decision making can keep moving during lockdown. Of course, on the other, it gives rise to some understandable concerns about lack of involvement by the public or by democratically elected councillors. And there's already been a question about this, which I will take at the end of the talk. So some schemes involve a meeting over, for example, Zoom, with those councillors as consultees, not decision makers, but consultees, whose views are canvassed with the officers, and then the decision can formally be taken by officers. Do remember, both applicants and officers, all delegated decisions, you've got to have a statement of reasons, either for refusing them or for granting them. But what about those councils who want to take advantage of these new regulations and hold a virtual committee meeting? First challenge, under the Local Government Act 1972, you need a quorum of members to be, quote unquote, present. Now, before the regulations, that meant people sitting in the same room. No longer, of course. Under the new regulations, there are 3 tests for being present, and members need to meet each of them. First, other members. You as a member need to be able to hear other members they need to be able to hear you. And where practicable, so not always required, you need to see them and they need to be able to see you. Second, members of the public who are entitled to attend and speak, it's the same formula. You need to hear them, they need to hear you. And where practicable, so again, not always, you need to be able to see them and they need to be able to see you. And then the third test relates to other members of the public, everybody else. They need to be able to hear you at least, and where practicable, see you too. So that's the approach for members, but what about everyone else? What about members of the public? They too can be present and can access meetings remotely. And that's now defined as to include access by electronic means, which is said to include telephone, video, webcasts, live streaming. There's a general requirement in the public body's Admission to Meetings Act 1960, which is still in force for meetings, most meetings anyway, to be open to the public. And that too now includes being open through video conferencing, through live webcast, through live interactive streaming and the like. And to state what is obvious, that will present more of a practical challenge for some local planning authorities and for some communities than for others. Many committee meetings are already live streamed, and even for those which already have the tech in place, the regulations herald a very different way of working, which I think makes it all the more commendable that, as we will see on the next slide, several councils are adapting so incredibly fast. If you have a spare hour or so after you're done with us today, do have a look at Kensington and Chelsea's virtual committee meeting earlier this month, only 5 days after the new regulations have been published. As you'll see, they use Microsoft Teams with all but one member on video, officers also on video. It worked, as you will see, incredibly smoothly. It's a shining example, I think, for how this can be done and done well. And the speed with which it was put together is quite remarkable. Of course, Kensington and Chelsea are not the only council worthy of real praise. On the same night, the 9th of April, 5 days after the regulations came into force, there were virtual planning committee meetings in Melton and in South Somerset. And albeit the South Somerset meeting made national headlines for some of the wrong reasons, as you may have seen, what is really heartening is that that council has made clear that a small number of ill-willed trolls with fake names like Mr. Dover, first name Ben, will not stop them from continuing to press ahead with virtual meetings, to which I say, bravo. And I also give you a short list on the slide, and it's already not complete because it's growing every day, and it's grown even since I wrote these slides earlier in the week. I give you a list of those councils teeing up virtual planning meetings for this month or for next. Lots of helpful lists on the internet of what councils are doing. And thank Leicester and Charlotte at Barton Wilmore for letting me use their very comprehensive table when I was putting these slides together. Many more councils are following and will follow suit, no doubt, albeit the majority are currently exploring their options. Understandable, given this rapid pace of change, they want to get it right. But of course, time really is of the essence here. And as Barack Obama used to say, we shouldn't let the perfect be the enemy of the good. There are, we should note, a minority of councils who are not yet interested, so far anyway, in embracing the possibilities of the new regulations and have decided to more or less shut up shop, which is unfortunate, to say the least. Let us hope that their numbers dwindle as more and more councils across the country show us how it's done and how remote decision making can be a great success in these extraordinary times. Unfortunately, as commendable as the response of the ministry and many arms of local government has been in the last few weeks, the same can't yet be said for the planning inspectorate. Sasha touched on this in his talk. I will go into it in just a little bit more detail on this slide. Appeals against refusals of permission can still be lodged. They are still being validated, but the planning inspectorate has decided for now that there will be no physical site visits at all. Virtual site visits are being trialled. A decision has been issued earlier, well, it was the end of last week, which relied on agreed images provided by both sides without the need for a physical site visit. I've been asked a question about that, so I'll come back to that at the end of the session. But for now, and for many written reps appeals, no site visit will delay the hope of any decision. And when it comes to hearings, or inquiries, and indeed when it comes to plan examinations, well, it's a total standstill. Everything has been postponed. The concern the planning inspectorate tell us is how members of the public can participate fairly over things like Microsoft Teams or Zoom. Is it a concern? Of course. Could it be managed, and managed quick, if it were decided that keeping the appeal system going is a critical priority for the planning system? Yes, it certainly can. See the heroic efforts of the court system, including the planning court, who have already adapted to multi-party, multi-week trials, open to the public, with cross-examination of experts and the rest, all over video conferencing. See also the proposal for the Grenfell inquiry to get back up and running shortly using video conferencing software. My goodness me, if ever there was a tribunal for which public participation is an overriding imperative, that's the one. PINs are moving forward, albeit a fair bit slower than many would like to see. They are holding a few trial hearings and inquiries over video technology at the end of this month and in May, but only for simple and uncontroversial cases. But there are so far not even any public plans for rolling out those trials to the rest of its ever increasing stalled caseload. And as I said in my piece on procedural fairness on planneracts.com, there's the plug, do go and have a look. I see nothing material in the law of procedural fairness that stands in the way of PINs moving and moving quickly to adopting remote procedures pronto to catch up with the ministry, with local planning authorities and with the courts. My view is there's a good case for the MHCLG introducing procedural regulations to move PINs along and to point the way forward for remote decision-making and appeals, albeit I've seen absolutely no evidence so far that any regulations are on the cards. So, as President Bartlett used to say, what's next? We've already seen a remarkable change in a very short period of time. And I note again that as well as councils deciding applications virtually, the planning court's been up and running virtually for weeks now. I did my first virtual hearing back in the middle of March, well before lockdown. It all ran very smoothly. I identified two areas that need urgent work, and the first is helping more and more councils to get up and running with virtual procedures. And on that front, can I commend to all of you the stellar work, I think, from the Planning Advisory Service, the Planning Officers Society, and by LLG, lawyers in local government, who have all produced incredibly helpful and practical advice notes on how the challenges of virtual meetings can be successfully managed. If anyone wants copies, just send me an email. Second, as I've said, PINs needs to get its skates on, and appeals and planning examinations need to start moving again urgently. Lots of other reforms need urgent discussion, including on SIL and how to manage consents which are about to expire during lockdown, but happily, my time is up. Thank you very much for listening, and back to you, Sasha.
Thank you very much, Zack, for that very good talk. And also thank you to Matt for both those contributions. So we're now going to do the question answer section. I'm going to start off answering my questions, then we'll move on to Zack and then Matt. Before we do that, I thought just to check who was still listening assiduously, we'd just do best lockdown story. And obviously, I think the winner goes to the rescuing of the 4-year-old Spider-Mans. I wanted to add a couple more which weren't given on this Zoom, on this webinar, but someone who went out to rescue an Amazon parcel left outside their door. It wasn't so outside because as they went to retrieve it, the door slammed shut, leaving them outside. And also a member of our chambers who will unquestionably remain nameless, who was concerned about doing a telephone conference in the High Court without having access to his wigs and gowns. But those are two of the lockdown stories that have emerged from Landmark. Anyway, now we've had some excellent questions and answers. Thank you so much. And I want to just deal with a few of them. I think there's one information I do want to give. I've been told by a very eminent member of the landscape profession that the Landscape Institute is considering and drafting guidance as we speak on how to identify valued landscapes. So look out for that, and hopefully that will seek to provide clarity. So could all those involved in drafting that please try and provide some clarity so it's not yet another lawyer's fest. Secondly, I was asked a question which I think is quite interesting about, is it inevitable that there will be a valued landscape if you have a site within a national park? Well, because of the assumption about statutory status, you would assume that in 172 terms it would be considered a valued landscape by definition. However, as I discussed with the cumulative interpretation, where inspectors seem to be looking at the statutory status plus some form of demonstrable physical attributes, someone might be brave enough, a decision maker, to take the view that notwithstanding its statutory status, it didn't have the demonstrable physical attributes, but I don't think so. My judgment would be that your starting point would be that a national park site would be considered a valued landscape. Next, I was asked a very interesting question about what will be the effect of the consideration of accessibility because of COVID. And I think, frankly, I don't really have a clear answer. It could go one of two ways, because clearly all of us have shown that we can be sufficient to a degree from our own homes. Maybe that will relieve the pressure for accessibility, or it could go the other way and show how important it is to have access to essential services and facilities in something as unprecedented as this. You can imagine 2 months ago in a cross-examination putting the point, well, come on now, it might be the circumstance where we're all in our homes for at least 2 months and you'd be literally laughed out of the inquiry, but it's been obviously a very, very real happening. I was also asked my penultimate question I want to address relates to MOL and Greenbelt. I obviously dealt with very special circumstances cases for the Greenbelt, and I've been asked the question whether Metropolitan Open Land has the same considerations. My judgment is it does. I know of one appeal decision relating a significant proposal on MOL in Bromley last summer. In that case, the inspector was satisfied there were very special circumstances. I would still take the view that generally housing need, whilst it clearly could constitute a very special circumstances for MOL, would still be a difficult hurdle to attain. I was then asked finally the question about percentage of costs allowed, and I do remember looking at some of the statistics some time ago. I think the reality is that the costs applied for is reasonably low in the average appeal. I'd also say that the costs awarded is pretty low. I would say that it's higher clearly for procedural breaches. Inspectors are much more willing to grant procedural breaches such as a late submission of a proof of evidence or producing a rebuttal a day before the inquiry commences. Much higher percentage of awards than for substantial applications which relate to an unreasonable decision of an LPA to object to a proposal or an appellant promoting and continuing with appeal that had no reasonable prospects. I would say that I think in my experience, the percentage of cost is probably declining and inspectors are getting more reluctant to issue those powers. Finally, I did just wanted to say in relation to the MPPF and my comment about what might happen in the autumn, and let me make it clear, I have no inside information as to what the government is intending to do, but usually in times of economic hardship, in my experience, the planning system is always perceived to be a major vehicle to assisting in economic growth, and I wouldn't be surprised if paragraph 11 was tweaked to give more weight to economic benefits or even promote a blanket presumption in favour of development, irrespective of some form of break, such as sustainable development. But my judgment, and I'll have a sportsman's bet with the participants, there will be a tweak to the MPPF in the autumn or early next year to reflect the imperative to bring about economic growth. So those are the questions that I've addressed. I will address the other ones in a written form that will go around to all the participants. Now, then let Matt, did you want to address some of the questions that you picked out, please?
Thanks, Sasha. Yeah, I've picked out 3 questions which I want to answer. The first is a question which often gets asked, namely, how can the mere fact of policy compliance be regarded as a benefit? And it's a very, very common question that's asked. It's a very good question as well. And I think that the answer is that you need to distinguish between two different things. On the one hand, you need to determine whether the proposal complies with the development plan. And that's where you're not looking at whether something is a benefit, you're just looking at whether it complies with the policy. But then on the other hand, you need to look at the balancing exercise, which is required by various different paragraphs in the NPPF, including the tilted balance. And once you're into the balancing exercise, you're not necessarily just looking at issues of does it comply with the policy, does it not? You're looking at what's this scheme actually going to be doing? What's it actually providing? And in that context, something like the provision of affordable housing, even if it's according with a policy in the plan, is a benefit to the scheme. It's a benefit that's being provided by the development. The other point to make in relation to this question is that even if something is merely policy compliant, it might be the case that the decision maker says it's a benefit, but I'm not going to give it more than moderate weight. And that's as a contrast to, for example, a proposal which goes above and beyond what the policy requires. That might be a justification for giving it more than moderate weight. And this leads quite conveniently on to the second question that I was asked, which again is a commonly asked question, namely, who came up with these terms, significant, substantial, moderate? Where did they come from? What's the basis for applying them in the planning balance? And can you use other terms like limited or minor or moderate? And the answer is, well, there isn't really an answer. No one really knows where these concepts came from. They're not in the statute. Sometimes you see them appearing in various policies, but primarily the decision's been taken both legally and in terms of policy making that these are concepts which are best left to the decision maker in the exercise of their planning judgment. And at various times there've been calls to come up with some sort of more rigorous standardized weighting process. So, for example, a numerical process, you might give a number, a weighting of 1 to 10 for particular benefits and harms. And this has been discussed. Lots of people think it'd be a much better idea. And then you'd go through a sort of almost arithmetical exercise to decide whether to grant permission or refuse it. But the problem with something like this is it's taking you away from what is essentially a very nuanced exercise. It's a question of judgment, qualitative judgment, as opposed to just totting up numbers in terms of benefits and harms, and that's why there's been a reluctance in the system to try and formalize these sorts of weightings too much. So there's still a lot of open-endedness, but I think my judgment is that that's a good thing, because it means that it enables decision makers to operate their judgment, their balancing exercises in an unconstrained way, even if that does lead in some cases to ambiguities as to what they mean. And the final question I want to answer is how consistent do I think the Secretary of State has been in terms of ascribing weight to the provision of housing in their decisions over the past 12 months. And I think overall, I would say the Secretary of State has been fairly consistent. The consistent position seems to be, I mean, I can't say for sure that of the 17 decisions in every single case, the word significant weight has been used, but by and large, significant weight seems to be given by the Secretary of State to the provision of housing. There will be variances on that, which will largely be determined not by how much housing is being provided, but by other factors in the balance. So, for example, is there a housing land supply? Where is the housing going to be? Is it in a location which is acceptable? And I think one of the interesting observations from one of the decisions that I went through is that even where there is 5-year housing land supply in place, notwithstanding this, the provision of market housing as well as affordable housing was given substantial weight. So I think overall my answer would be yes, there is consistency, albeit not necessarily the exact same word used every single time. So they're the three questions I wanted to pick up, and I'll now pass over to Zack to take it from there.
Thank you, Matt. A few questions have been generated by my slides. I'll pick 3 or 4, and then we can draw it to a close. The first question is about whether or not we know that PINs have kicked off with their use of virtual sites. And as I indicated during my talk, the answer is yes, it has started. And the evidence of that is 16th of April, appeal to 76 days ago for an appeal at Lexham Mews in London, an appeal against the refusal of a certificate of lawfulness for something as glamorous as a chimney. It was a written rep appeal. The inspector was called Inspector Boffin, so it was an appropriately named inspector. Do send me an email if you'd like a copy of the decision. It was obviously a relatively simple case as they go. Still, the inspector in the decision letter notes that the site everyone had been planning for at the end of March wasn't possible because of lockdown, but was happy to decide the appeal anyway, and indeed to allow the appeal on the basis of that the parties agreed adequately represented the site, etc. So obviously sites of a larger scale and complexity are likely to present challenges of a sort, as I touched on in my talk. The second question I wanted to touch on was about a fear of planning decisions being taken behind closed doors. It's a concern, I think, that has particular force for councils which have triggered emergency decisions, something I talked about, albeit in those cases, remember two things. Firstly, the right and ability to put in consultation responses unaffected by COVID, by lockdown. Second thing is that officers have to give reasons for their decisions, another point I made. So if there's something wrong with those reasons, the decision may be vulnerable to judicial challenge in due course. For committee meetings, as I've explained, however planning committees decide to arrange themselves, the regulations absolutely require the public to be able to observe where appropriate, participate in the meetings. So what's really important is that those who want a voice, pro themselves, at least for now, a mobile phone, or better still some sort of tablet or computer or something like that to enable them to observe the meetings as they're happening. The third thing I'm asked, not using size applications may discriminate in some way against older people who can't leave home. Remember, site notices under the Development Management Procedure Order are not the only way that you're supposed to be publicising applications. Depending on the scheme, you might need to put an advert in the newspaper. Sometimes you've got to serve notices on neighbours. It's perfectly possible to be notified within the terms of the order of important local planning actions without leaving the house. I think it's prudent in these unusual times for councils to consider steps can safely be taken to make sure members of the public are notified of what's happening. So don't rely on site notices alone. Lastly, I'm asked, do I foresee any legal challenges to decisions where technology might fail mid-committee meeting so as to prevent full public participation? It's a good question. I think this is going to need real care. If, for example, the web stream fails for part of the meeting, then depending on the case, the meeting may not have been fully public. So yeah, the tech needs monitoring very carefully before and during the meeting. If there are failures, it's going to be better to pause or to adjourn the meeting and get it sorted than take a risk of making a decision in an unlawfully constituted meeting. Now, the other questions, so far as I can, we'll on to in writing. Thank you very much. I'll pass back to Sasha.
Zack, thank you so much, and thanks, Matt. Can I just say, well, we're delighted we haven't had a South Somerset position at our webinar. We've got through without being firebombed by anything that we shouldn't be seeing. Can I genuinely, on behalf of Zack and Matt and the whole of Landmark, can I thank you so much for joining in today? We think it's been really, really excellent, and I really want to thank you for your joining us and helping make this such a success. It's been brilliant. And can I also say, do feel free to pass any feedback on. We are willing and we want to obviously improve our webinar program. If you've got any suggestions, don't hesitate to get in touch with the marketing department. And also, can I say finally, I want to wish you all a very good rest of the day, and I hope the lockdown is as bearable as it can be for all of you, and I look forward to seeing you with Matt and Zack in person as soon as we're able to. So thank you very much. See you all soon.